Okay, I think that we are ready, ready to get started. So hello and welcome everyone. Thank you for joining our today's webinar where we are going to discuss the new CVP rule that now allows to reach consumers by text, email, and Facebook starting next year. My name is Nick Varnitski. I am co-founder and CEO of Armada Labs, a leading provider of fintech software development services. Now, really quickly, just as a reminder, although I'm sure this is not your first webinar, feel free to type in any questions by clicking that Q&A button on the lower part of your screen, and we'll make sure to address them towards the end of our discussion. And today, I'm very excited that we are joined by our guest speaker on our panel, Jay Spruill. Jay is an attorney at Woods Rogers law firm. Jay works with a lot of fintechs, finance companies, startups, and just all sorts of financial institutions, helping them to navigate the complex financial regulations. Also, one of the areas of his focus is compliance with the laws administered by CVP. I know, Jay, do you have anything to add?
No, thank you very much, Nick. It's good to be with you and the Armada Labs team and the folks who have taken time to join us today.
Great. And Jay is also joined by Eugene Pratasenia. He's a founder and managing partner at Armada Labs, the fintech software development firm. Now, Armada works with really fintechs ranging from startups to Fortune 500, helping them build their technology, as well as Armada has a number of its own products that are built for the financial services space. And the first question that I wanted to open up our discussion is directly related to the topic of our webinar. So on October 30th, CVP issued the new Fair Debt Collection Act rule. Now this rule revises the Fair Debt Collection Practices Act, and recently it got its own somewhat controversial buzz in the news and media. I've seen some articles where consumer advocates are saying that now collectors will be bugging consumers on Facebook. It's going to be all terrible. I've seen some other articles talking about how this rule opens new opportunities and new horizons for collection companies and lenders, and how it's going to improve their efficiency. So Jay, I wanted to ask you if you can give us an overview of this rule, and also kind of why do you think it's a subject for that many discussions in the media?
Sure. Well, let me start by giving a little historical background so we'll have some context. The Fair Debt Collection Practices Act was enacted in 1977. It's been on the books a long time, obviously. And we've really never had any regulations under that law, unlike a law like the Truth in Lending Act, where we have regulations and those regulations are updated periodically. We haven't had anything under the Fair Debt Collection Practices Act. But things changed with the enactment of the Dodd-Frank Act of 2010, which granted the Consumer Financial Protection Bureau rulemaking authority with respect to all federal consumer financial laws. Mm-hmm. And among those laws is the Fair Debt Collection Practices Act. So the CFPB has been working on this rule for many years since it got this authority. And this regulation, this rule we'll talk about today, is the first regulation under the Fair Debt Collection Practices Act. And so in general, I would say about it is it's really, the regulation's really about providing rules on how an old law applies to new ways of communications, electronic communications. If you think about it, in 1977, when the Fair Debt Collection Practices Act was enacted, debt collectors would contact people pretty much exclusively by calling their home phone, sending them mail, US mail. There was no such thing as email, text message, Facebook. So as is often the case, we have the law having to catch up with the realities of the way the world works. And that's what the CFPB has attempted to do with this rule. And we'll talk about more particulars, but I would say just generally, the rule establishes the validity of electronic communications in debt collection efforts, provides safe harbors for debt collectors that follow certain procedures and how they handle their electronic communications. And this is an important point, Nick, and kind of responds to your comment. It allows consumers to maintain control over how they get their communications. What are the if they don't want to get email, if they don't want to get text, they can control that. And I think to some extent that's lost in all the news media that, oh, that Joe Smo consumer is going to get harassed with emails and text. Well, as we'll discuss, that's not the case. There will be opportunities for the consumer to control how communications are made from debt collectors. So, and the final point is, this rule is really about promoting efficiency. The more effective communication there is between a debt collector and a consumer, the better, more likely it is that the issues can be resolved. So it's good for debt collectors, it's good for consumers. That's a general overview.
All right, no, great. Thanks for the summary, Jay. So now let me clarify something. I know that we not only have some collection companies here in this webinar, but we also have a lot of lenders and just fintechs in general. And now, does this new rule only apply to collection companies, or should lenders also pay attention to it and be aware of this new regulation?
Well, that's a great question, Nick. The Fair Debt Collection Practices Act applies to debt collectors, and debt collectors are defined as those who collect debts on behalf of others, someone that's collecting the debt for another entity or another person. So a creditor that's collecting its own debt is not a debt collector, and technically the rules in the Fair Debt Collection Practices Act and generally in the new CFPB rule would not apply to creditors. Nevertheless, I think this rule is important for creditors for three reasons. One, it does actually apply with respect to how email communications can be facilitated by a debt collector. There's a way that a creditor, in the process of handing off a debt to a debt collector, can send a notice to its customer, the consumer, and facilitate the consent, if you will, to allow that debt collector to send emails. Secondly, most states have debt collection laws on the books, and those state laws in many cases can affect creditors collecting their own debts. I will use the example of California, which provides in its law that many of the provisions in the Fair Debt Collection Practices Act apply to creditors collecting their own debts. So lenders on the call who are making loans and worried about collecting on those loans, this could affect what they do in their many states where they have customers. And thirdly, the final reason this is important for creditors, for lenders, not just debt collectors, is, as lenders well know, they are subject to the Dodd-Frank Act's prohibition on unfair, abusive acts and practices. Well, a lot of the rules in the Fair Debt Collection Practices Act deal with unfair, abusive, deceptive practices. And there's always this concern that a regulator, enforcement agency, a court can look to the Fair Debt Collection Practices Act and what is deemed unfair or deceptive or abusive there for purposes of determining that a particular lender violated the Dodd-Frank standard. So a lot of lenders adopt the Fair Debt Collection Practices Act standards as a matter of best practices. So those are the reasons that it's important.
No, that's great. That's very helpful. So let's say if I am a lender or collector, now does this new regulation mean that I can simply start blasting all of my consumers with emails next year, asking them for payments? I mean, is it really that simple, or is the devil still in details and there are still requirements and regulations that everyone needs to be aware of?
Well, Nick, the devil is always in the details. So first, the rule becomes effective November 30th, 2021. We have about 11 months. And some might groan that we can't take advantage of it yet, but the good news is that it gives plenty of time for those in the industry to make sure their systems, their procedures are compliant with the new law before taking advantage of what it has to offer. For emails, as I said, the new rule recognizes emails as a legitimate form of communication by a debt collector and brings certainty as to how these emails can be sent, and creates a safe harbor. And that's the most important part, I think, what I have to say about why these procedures are important and why compliance is important, because the safe harbor is about avoiding liability by doing what the regulations say you need to do. Mm-hmm. So with emails, the procedures that must be followed really kind of relate to consent, either implied consent by the consumer to receive emails or express consent, their disclosure requirements, and their measures to protect against inadvertent disclosures to third parties. Because when you're sending emails, you don't know who might see that email. Mm-hmm. Same with text messages. Mm-hmm. There are different rules depending on if this email authority is obtained by the original creditor, the original lender, or by the debt collector. So if it's the original lender, that lender, if the lender has communicated by email about the account, that lender can send a notice to its customer, the consumer, before handing off that debt. And the notice would say that we're going to pass this debt off to a debt collector, and the debt collector may be able to contact you by email. If you do not want email communications, you need to opt out by a certain date, which needs to be at least 35 days after the date of the notice sent out by the creditor. Okay. So if the creditor does that, then the debt collector can send the email. Also, the debt collector can get consent, if you will. One way is that if the debt collector simply sends a message saying, "Hey, can we contact you by email?" and the consumer says, "Yes, that's fine." That consent is valid. Also, if the consumer communicates with the debt collector by email regarding the account or regarding the debt, then that is email authorization as well. So again, it's important to follow those procedures because there's a safe harbor. I do want to mention, though, with respect to the lender facilitating this by sending the notice, the domain name of the email must be one that's publicly available, like a Gmail, AOL. It can't be an employer email account.
Okay, yeah, that's I guess not as easy as it sounds. So now, what about texting to consumers? Do the same rules apply, or I suspect is it even more complicated with texts?
Well, for text communications, the rules are fairly simple, Nick. except there's no lender or creditor safe harbor. The lender can't facilitate this kind of the approval process, if you will, or text message authority. And again, it's kind of the same principles of consent, disclosure, and opt-out authority. The debt collector has to handle this. The debt collector may send a text message to a consumer debtor if the consumer used that telephone number to text the debt collector. In other words, if a debt collector gets a communication by text message from the consumer, it can use that number.
Yep, they have to respond.
Yep. Also, if it's if the debt collector wants to get consent from the consumer, that always works. Now, here's some little twist on it. Within 60 days, or looking forward 60 days from when that text message came from the consumer or when consent was obtained, the debt collector has to get another text message or has to renew the consent unless it confirms that the phone number has not been reassigned through looking on a database, a national database of phone numbers, to make sure that phone number is still the debtor's phone number.
Oh, valid. Got it.
So the concern is that these texts might go and the number's been reassigned and they go to a third party and the consumer debtor's privacy has been violated.
Yeah, absolutely. Got it. So now another thing that seemed to me really innovative about this new rule, considering that the original law is coming back from the 70s, is that it talks about social media and then Facebook. And again, naturally, that scares a lot of consumer advocates. You see all those articles saying that, hey, now collectors will be posting in your Facebook that you owe them money, your family, your friends, everyone will know that. Now, I'm pretty sure this is definitely not allowed. Are there any other specific rules towards the social media communication?
Sure. Well, the CFPB's rule recognizes all electronic communications, including those through social media. So you can do that. But I would point out a couple of things. One, the safe harbor that for emails and text, if you follow the procedures, don't apply to social media communications. And secondly, there is a provision in the regulation that says that a debt collector may not use social media if the communication is viewable by the public or by the debtor's, consumer's social media contacts.
Okay.
So there are risks with social media, much greater risk than you have with the email and text authority. And so, and if you do send a social media communication and it is viewed, then that's a violation of the Fair Debt Collection Practices Act, based on it being an unfair or unconscionable means of communication.
Right. Okay. No, makes sense. That's really encouraging. So now I know Armada has been getting a lot of questions, a lot of feedback and requests from its fintech clients, from its lender clients. Now, Eugene, can you share what you've been hearing lately? Is industry in general excited about this new regulation? What do lenders think and say? Do they feel it creates some new opportunities for them? And just overall, what are they looking for?
Sure, absolutely. As you know, as Jay did mention, the new rule will go into the effect, and we have about 11 months. So over the last 6 weeks, we did get a full spectrum of emotions, questions, ranging from big excitement, ready to pop the balloons, all the way to the concerns and kind of careful optimism from our clients. But overall, I would say, since our client base is present in the fintech space related to the collection space, like our ARM industry, we've been getting those questions. And if I can categorize those requests or questions, I would say one of those topics is pretty much ability to reach consumers that they were not able to reach previously. That will open up the opportunity that kind of evolves into the questioning of how to enhance either their current platforms or build out additional module or functionality within the lending platforms. That kind of definitely comes up on the table a lot. There is a possibility to deal with increased compliance that basically allows to track better tracking and tracing that would enable to determine through the new ruling, and obviously improved efficiency of the processes. That means the processes become more advanced, more streamlined, and that definitely comes up through our clients. On the collection side, obviously, that collection efforts, they can become more streamlined. They can be more categorized, that you can differentiate between different sources what triggered in terms of future provisioning, with the new ruling, they can better define which efforts of your customer service or collection department led to some results.
Better tracing, basically. Yeah, better tracing. Okay. No, that's great. That's really interesting. So now let me probably ask you both a question. So last year in 2019, Millennials became not only the largest group within the economically active workforce, but also just the largest generation in the US in general, way surpassing the baby boomers. Now, do you think that the adoption of this new rule is somehow related to this fact? Do you think that somehow CBP realized that by not allowing collectors to text and emails, it's either depriving millennials of some of communicating channels, or maybe even giving them an excuse to ignore the collection efforts? Because we all know they don't want to answer the phone calls. They don't want to open the mail. What do you think, Jay?
Well, I think that's an excellent point, Nick. Certainly millennials are not relying on landlines, often don't have landlines, or and don't like opening mail. And so I do think the CFPB was cognizant of that and in the rules embrace of electronic communications in recognizing millennials' preferences. The changes were really needed. This is the way of the world today. I'll tell you a little funny thing, that in the statute, and I don't know why this is in there, but it actually uses the word telegraph as a form of communication in the 1977 statute. So just
millennials to read it as telegram as the messenger.
So again, I think there's a lot of, as you've mentioned, Nick, there's a lot in the media about those bad old debt collectors going out and collecting debts and using all these means. But really the aim of the rule, and the CFPB is about protecting consumers, was making this work for consumers and for debt collectors. And I think that's goal is going to be achieved with these new methods of electronic communications being recognized.
On my end, I want to add to your comments, Jay. I want to believe the CFPB is innovative organization, that prominent thinking. So I don't want to talk and compare this old ruling from the 70s that we're discussing today to our long time overdue changes that need to happen in the healthcare industry, because we are still filling out PDF forms and faxing them. So that's kind of exciting and funny. But this new ruling, I want to believe it's definitely about inclusion. So because millennials are becoming more prominent and important group to ignore. So obviously in introduction of this ruling would definitely help to include rather than just hurt them, because without this old approach back from the last century definitely would been hurting them to some extent. I believe, like, customers and consumers, rather than just protecting them. But as you mentioned, protection is one of the goals of CFPP, and this rule definitely enriches this protection or helps to include this group into the that process. So,
Right.
Yeah, very good.
and Nick, I would like to mention that to our audience, like, if you have any questions, we are not trying to ignore them. We will address them later towards the end of the Q&A session. Feel free to post them. There is a button Q&A. And again, I guess we're killing it because everybody from kindergartners to elderly people know Zoom by now. So everybody is a pro in this area. Yep. But feel free to post questions. We'll try to address them, like, towards the end, and promise no question will be ignored.
Sure. Okay. Well, now that we've talked about what is allowed and not allowed, and what kind of opportunities it opens up, probably the next question that everyone has on their mind is literally how. So, the rule just came out. We still have another, 10 months to get prepared, but still this time will fly by quickly. So, question probably to you, Eugene, is what lenders and collection companies can do right now and within this next 10 months to get ready and to get prepared to take the best shot and to realize this opportunity that this new regulation is opening for them?
Well, it's always an easy question, but it's difficult execution. It's build or upgrade your existing system, build a new one, or buy the ready solutions. So obviously, if we talk about, like, upgrading existing system, if you have capabilities and either have like internal staff to do it, like, I'm pretty sure, like, 11 months is pretty much a good period to do it. It's going to be costly and but still doable. Building it from scratch, depending on the module or functionality that you're looking for. So it might be, like, realistic in some cases, depending on the case-by-case study. And ready solutions, yes. I mean, like, they could be, like, easy to do, but it has, like, pros and cons in that as well, because obviously you getting this quicker and compliant, but then you're dealing with either rental fees or monthly subscription fees, so that have to be taken into consideration. And one of our products, Paid, which is online debt negotiation tool that we offer to the clients. I mean, we've seen, like, a surge in client intake and boarding because even before the ruling came out. So, like, it's been some kind of great run, and especially in nowadays, like, don't want to repeat myself, but millennials are the group that doesn't like to open envelopes any longer. So, like, our product allows to extend the services rather than compete with the customer service and collections, and happens to be, like, we do have those communication means and tools in it, like texting or emailing, that automates the process, makes it compliant, traceable. And one of the roadmap features is definitely to add ability to communicate via social media and chatbots. So that would be my answer to your question.
Okay. I guess whenever you're building the platform, you always need to keep compliance question in mind. And I would say always make sure that you run it by your legal counsel, by someone like Jay, to make sure whatever you're doing is legal, right?
Yes. And Nick, I would just say that it's been mentioned a couple of times, getting the procedures right is important, so that, a collection company can avoid liability for an unintentional error. For example, there are restrictions on disclosures to third parties. Well, if you follow the procedures and in terms of the email and providing the opt-out as well as a text message, and someone actually sees an email or a text message other than the debtor, the debt collector is not going to be liable if it's followed the procedures to ensure that those things are protected. If it doesn't follow those procedures, it can be liable. And I think it's worth mentioning not only the protection, but the potential liability for failure to not do what the law requires. It's the Fair Debt Collection Practices Act sees more litigation, probably, I know the Truth in Lending is a lot, but it's just so much litigation under this act based particularly on how the liability section works. There's class action exposure, attorney's fees can be recovered. And so plaintiffs' attorneys really like this law. and all the more reason why we need to be careful and comply.
Okay, no, that's a great point. I was actually just recently reading somewhere about a case where a collector was required to provide a written notice under FDCPA, and they've done so. They've sent an email that had a link to this notice that consumer had to click, which again, to me as a consumer is perfectly fine. It makes sense. You get something, you see that blue link, you click on it and you read it. But the court ruled that was not sufficient, and that that text, that notice, was actually supposed to be inside of the email, visible without an extra click. Yeah, that's kind of a great case that can show what can happen if you don't run it by your legal counsel.
Yeah, yes, indeed. That's a good case to cite. I think you're talking about the Seventh Circuit case, Lavallee versus Med1 Solutions. And you're exactly right. The issue there was there was an email sent with a link to the validation notice. The email did not mention the word debt, so it was deemed not an initial communication. And the debt collection firm got in a lot of trouble. So yeah, it just shows little crazy things can get you in trouble, and that's why we have to dot our I's and cross our T's. I would mention one thing that's in the rule that the audience might have some interest in, and I don't want to get too much in the weeds, but the e-Sign Act requires that when a law says a disclosure must be in writing, you can send it electronically as long as the consumer consents. Now, bear in mind what we've talked about today with the communications are just regular communications where you're trying to collect. But let's talk about, say, the validation notice the law says it has to be in writing. Can you send that electronically? And the CFPB has not been too clear on all of these, how this all applies, but they did say in this rule, buried in the section analysis, that the validation notice can be included in the email that is the initial communication and doesn't have to be sent in the mail. It can be an electronic validation notice. So that promotes efficiency for debt collectors. So that's a bit of good news. As far as the other types of anything else that the law specifically uses the word in writing, it's less clear because the CFPB did not really clarify.
Okay. No, that's great. Thanks for this additional information. So Eugene, I know that you're involved in a few projects at Armada where you're working on implementing Armada's paid solution for the clients, so they would get ready to go live fairly quickly. Can you share maybe some real life examples of either some features that the customers are looking for, or maybe just overall recommendations from both business perspective and from technical perspective, some recommendations for our attendees of what they should be paying attention when they are deciding to either build or choose a platform that will allow them to take advantage of this new rule?
Yeah, as I did mention, in paid product, solution, it is an online negotiation platform. And one of the things that I would definitely recommend if you decided to build yourself is factor in and keep the attorneys happy is the ability to quickly adjust the content to be flexible, make the platform flexible, so it allows you to change this content of their pages, disclosures, and other aspects on the fly, rather than just depend on the developers. Because once you end up in this, clash of clans, between attorneys and developers, it might take some time, which increases the exposure of the company, and definitely have this be done on the fly helps it a lot. Tracing capabilities, obviously it's important, as I did mention previously. And what we accomplished, we do record every single step of the consumer within the platform. That allows us to kind of deliver this results to the client, and it can be used, I don't like to say protection, but definitely helps them in court or other aspects if it's ever been challenged or will be challenged by the consumer saying that, hey, I haven't authorized this, or I'm not sure what happened. We can reproduce the whole journey of the consumer within the system, and that's definitely helpful and resonates well with the clients. Within our communication platform, we've paid it, the great thing I think that you want to keep in mind when you're building it is an ability to adjust templates on the fly, or have this freedom to kind of readjust them when using different technique. Because obviously, if you're dealing with their, cell phone bill that's basically maybe a couple months old, or paid loan, versus something that's 2 years old, you want to have a different messaging, but ability to do it on the fly would definitely increase the campaign success that we're seeing through our lenders, and collection companies utilizing different portfolios. Because having the ability to send email or text doesn't guarantees the success results. It's the constant, what we call it, the R&D, that allows to kind of pull the strings and see which templates resonate better with the different groups of consumers. Definitely helps to bring the results and stay compliant, as the attorney is saying. Those are the, I would say, recommendations that come to my mind. And obviously, give consumer the option. Resonate well, make sure that your platform is mobile optimized. Again, depending on the scenario, some clients might consider building the downloadable app, but unless you have tens of thousands of users, probably not worth it to spend the energy and time and money on building the application, when you can build the design of your system responsive, make it responsive. That helps to be available on the mobile devices or iPads. That kind of, again, helps to address the population that doesn't really open an email and only looks at on a desktop application. So it delivers the ability and almost streamlines the process when you click on that text message that you just received on the link, and it's a website that opens up right there, and it's optimized, so it allows you to navigate easily and understand what they're looking for. That definitely brings the results. And especially as we know, nowadays more and more consumers have a really short attention span. So you only have so much time to kind of get their attention while they're busy with their lives or social media or something, so they can address their situation, address the debt, and move on. And obviously, options depending, if you're talking about we haven't paid the option to pay balance in full or unrelated payments, or negotiation option that mimics the behavior of the life collector. That could be maybe a suggestion if you decided to build yourself, include it into your platform. Why? Because then you're addressing the whole spectrum of the debt, either on the time perspective, when you're talking about slightly delinquent debts that could be saved and brought to the current, all the way to the charge-off accounts, and before you even give it to the outside collection companies, or as a collection company, you extend the services of and reach to the consumers beyond your regular customer service hours that your office is open. So that would be kind of summary of things that I think would be important. Again, definitely there are some other opinions could exist, and definitely would love to collaborate on them more if there was a chance to talk about.
Great. Yeah, thank you, Eugene, for this insight. I'm sure it's very helpful. No, that's great. First of all, thank you everyone for your time. Now our session is coming to the end, and I think we're ready to move to the Q&A. Also, once again, feel free to type in any other questions anyone has, and I would start with the first question, which I believe is probably for Jay. At least you'll answer it better. So the question is, which rules apply to commercial debt versus consumer debt? So yeah, we will probably have a number of business lenders or collectors on our webinar, and can you maybe elaborate, Jay, how this rule apply to commercial collections, or which parts of the rule apply?
Sure. So the FTCPA and the rule apply to the collection of consumer debt. It will not apply to the collection of commercial debt. Now, state laws could have specific provisions on the collection of commercial debt. But the rule we're talking about today is intended to protect consumers and not commercial entities.
Mm-hmm. Mm-hmm. Okay.
So, I'm trying to find the language.
All right, great.
It's just so, you know, I'm looking at the rule, for example, well, this applies, the new rule applies to debt, and debt means any obligation or alleged obligation of a consumer to money arising out of a transaction, et cetera, and it talks about personal, family, or household purposes, whether or not the obligation has been reduced to a judgment. So I don't know if the person who submitted had something else in mind, but generally commercial debts, as in a lot of commercial transactions, you don't have to worry about these consumer, these truth in lending, like fair and the Fair Debt Collection Practices Act and other consumer laws. So that hopefully is good news.
Does it
Okay.
mean that this is a wild, wild west for commercial lenders and collection companies operating in this space? So business as usual?
Business as usual. The thought always is in the law that commercial entities are much better able to fend for themselves. They're sophisticated enough that they don't need the protections that you see in these consumer laws.
Right. Okay, and I have another, I think, related question which puts somewhat of interesting spin on the previous question, also related to commercial debt. Would the rule apply to attempts to collect a commercial debt from an individual guarantor who guaranteed a commercial debt? So what if we're transferring this commercial debt to trying to collect from an individual guarantor?
Again, I look at the definition I'm looking at right now. So, all of the rule applies to debt collection, debt collectors, and refers to debt. Debt means any obligation of a consumer to pay money arising out of a transaction that is primarily for personal, family, or household purposes. I think in the question you just posed, there's a commercial, was there a commercial entity guaranteeing a consumer debt?
No, it's like it's the otherwise. It's the
Okay.
debt is the commercial debt, but you have the individual who is guaranteeing this debt.
No protection for that individual, because you look at the purpose of the debt, and the debt was for a commercial purpose, not a consumer purpose, and that guarantor doesn't get any protections. It makes sense if you think about it. You can't have a situation where you have a commercial transaction, these consumer laws don't apply, but say, yeah, we're going to apply it to the person who guaranteed the commercial.
Right. It would be really convenient.
Yes.
Okay, excellent. So thanks for that answer. Yeah, looks like you're really popular, Jay. I think there is another one for you. For the communication sent by the creditor, passing email concern to the debt buyer, how does that communication need to be sent from the creditor? Can it be mailed, or does that communication need to be sent via email? I would think probably otherwise.
Yeah, that's a very good question. It can be either way. The law says it can be in the form of an electronic communication. It can be an email, or it can be sent in writing.
Yeah, I would say, why would you want to pay for the,
Right.
50-cent mailed letter if the email costs just a fraction of a cent?
Yeah.
Yeah.
I would just add that, it's a good place to add this important point. When the creditor lender sends that notice to its customer, the consumer, it has to make it easy for the consumer to opt out.
Mm-hmm.
Like if it's an email, there might be a link. Go here to opt out of email communications from the debt collector to whom we're referring this. If it happened to be a mail, it'd be something they could return included in the mailing. But you can't send them a message and say, we're going to refer this. If you have an interest in opting out, you can mail us a letter at this address.
Mm-hmm.
You see the difference?
What we do, sometimes in our projects, build bulletproof, double layer of protection, because each mistake might be costly, as you know, Jay, right? So it could become a magnitude of zeros in fines. So
Yeah.
what we do, we do make this easy to opt out from either email or text message, but at the same time, if consumer decides to be removed from the list, we do provide this to the clients, but then they actually somehow miss this list and try to resend it. So there are safety tools and processes built in place that we still stop this message or email to go out if it has been already removed from the list by the consumer previously. So that kind
That's
of
right.
Because just relying on the process, there are too many things could slip through the cracks, and just you cannot afford basically, especially if you're dealing with a large databases, large lists of consumers, dealing with that.
It's almost 2 levels of protection.
And I would say this even if I was not invited on this call by you all at Armada Labs, but I think what you all are doing and helping and your solutions are so vitally important. And companies and programs like what you offer are so necessary, because there's so many points of potential falling through the cracks, and it's just so hard. I mean, I'm a lawyer and have the hardest time getting all this down. And the advantage of automating some of this is it's just so important, and really relying on that.
Thanks, Jay. And I think that's a great segue to the next question that we have from one of our attendees. And that's probably for both of you. You can both share your experience. What database could or should be used to confirm a phone number did not change owners, rather than having to have the consumer to opt in again? So basically, how can you find out, and can you tell which databases to look, to integrate, connect to check whether the phone number changed consumers, the changed owners?
You want me to take that, Gene, or
Go ahead and start.
Okay. Well, I know the regulation says there is a database that has been approved by the FTC, and they had a reference. It was something I'm not familiar with. I'm trying to find it, and Gene might know, but there is a national database for that. And I'm sorry, I just don't have it off the top of my head.
One of the things that I've seen, when we do build and integrate, communication methods, especially through the text messages, and use some of the vendors, they have this in place. There are a couple of vendors that exist like in the market, like, you know, that can do it through their means and tools. But again, like I haven't seen the product that's readily available, like, you know, on the market that kind of guarantees this. It's almost that this OFAC list that kind of you have to kind of scribe it yourself rather than just using somebody else. Even though with OFAC there is a lot better situation because some clients, some vendors do offering this scribing services. But I mean, we can definitely, if you can provide your email address, like we'll do the more digging and reply back to you, like, you know, with kind of response to that.
Okay.
So I'll just add it. I just spotted it in the regulation. The regulation in the commentary says it's you can rely on the database established by the FCC and the advanced methods to target and eliminate unlawful robocalls ruling, as well as any commercially available database that is substantially similar in terms of completeness and accuracy to the FCC's database. I said the FTC, so I guess it's the FCC, Federal Communications Commission.
Yep.
Okay. Gene, can you find out more than I've given?
Yeah, absolutely. Feel free to reach out to either one of us, and we'll make sure to give you a more detailed answer. All right, and I think we have time for probably a couple more questions to address. So the next one is, how long in time is this kind of acceptance from the client when you ask for acceptance of email, like in text, that is 60 days? And being that there is 35 days to opt out, does the debtor buyer, does the debt buyer need to wait those 35 days before sending email? I think it's kind of a twofold question. So the first part is for the acceptance for the email and text, you know, what are those frames? And you know, then for the opt-out, if we send a message and someone has 35 days to opt out, do we have to wait for 35 days before sending email?
Yes. So the on the 35 days, the rule says that the notice that the lender creditor sends saying that we're going to hand this debt off and the debt collector can contact you by email, you have the right to opt out. The law says that the consumer must get at least 35 days to make a decision. So in the notice, the lender would say, submit this opt out or opt out by this date, which must be at least 35 days. That's with emails. And I guess the first part in terms of emails, if there is acceptance, those emails can continue. It's a little different than text, which we'll talk about. One important point, though, is in all electronic communications, there has to be a notice that the consumer can opt out at any time. The law says if you're sending those electronic communications. So I think that acceptance for emails is good. Again, if it's a handoff from the creditor, remember we talked about the creditor ensuring that it's a domain name that's publicly available, but otherwise that's good. For text messages, it's just very a little bit challenging because of that 60 days. You either got to, you recall we talked about the way that can be essentially authorized by the consumer is if the consumer sends a text message to the debt collector or the consumer consents. And then that kind of has to be either another text message within 60 days or renew the consent. And if you don't do that, then another option is to look on the database we talked about.
Okay, great. Thank you, Jay. And I think we still have a little bit time for literally the last question. And let's pick this one for Eugene. Now that's definitely for you. What is the implementation time for your paid product? If we start the process today, when can we go live?
It is like a loaded question. I mean, like, it's super fast and could be stretched in time. I mean, we, from our experience of boarding like large clients, like, organizations, is from our side, like we can spin off the initial version of paid it within 24 hours. So like assuming things are going super optimistic, within 2 weeks, client is up and running. But because there are some regulations or like verifications needed, blessing from the legal department, some decisions made from other departments on the client side. So the process could be longer, sometimes could be like months and a half, 2 months, even though like we've seen some of those clients like that. But in general, like, if we're kind of, both parties are ready to dance in the same page, we definitely can spin it off like the matter of like a week or two.
Yeah, I guess it's a two-way street. Everyone has to do their part. Okay, excellent. Well, I think that would conclude our today's webinar. I wanted to thank both of you, Jay, Eugene, for your time. It was really great, really insightful. Hope all of our attendees enjoyed it. And once again, if we missed someone's question or didn't have enough time to answer it, please feel free to reach out to either one of us, and we'll make sure to address this question either by email or by phone, whatever you would prefer. All right. Thank you, everyone.
We'd like to wish everybody healthy and sane holidays. So please stay safe and healthy.
Absolutely.
Very nice. See?
Thanks, everybody.
Bye-bye. Bye.
Bye-bye.